So by participating in the support group calls, you are acknowledging you understand there are no mental health providers or attorneys on this call, and that nothing said here is any way to be interpreted as mental health counseling or legal advice.
Rick or Sandy, are one of you willing to give a little brief testimonial? I know I'm catching you off guard on the impact that the communications negotiations roundtable has made for you.
It was very valuable for me because I couldn't see my blind spots. And I think that was the thing for me, that I thought I had it all figured out. And I clearly didn't. And learning from not only Cindy, but reflecting with other parents helped me to see those. And I've been able to keep those in my toolbox since.
Could you speak a little bit about the impact it's made with the different judges that you've had and how you've been able to use it for that?
I've been able to basically stay regulated. For me, it's been everything, because even though I didn't sometimes get to say what I wanted to, how I communicated was more important than what I said or did sometimes, as far as all the different communications with the court and moving papers, but also my former wife. And those were very important. And I'm only starting to see the results of those. Sometimes you don't see the results immediately. They take some time because the whole court process takes time, but you will see them. I've noticed them significantly, and I'm in a much better position because of it.
Thank you for being willing to, on the spot, say what you did. And I just want to acknowledge Rick, because after, I'm going to say 2 or 3 years in dealing with some of his litigation, he just represented himself for the first time. So, and he did an excellent job doing that, but it took a lot for him to get there, to understand, and get over the fear of that, how do I communicate, negotiate, talk to the judge, multiple listening to multiple people. So thank you, Rick, for saying that. Sandy, anything you want to say real quick, and then we're going to move on?
Being attacked by another parent for so many years, maybe a decade or two, but taking that communication roundtable helped me understand different personality and not to take their attack so personally anymore. And so maybe with that training, I feel like I don't take the judges comment about me so personally, which helped me stay grounded and then stay focused and win that case. But in normal basis, without children as well, or alienated children, when they express their anger, right? So then I get to understand, okay, that's just their way of communicate. That's just their personality as well. And then it expands to workspace, to stranger who attacks. These days actually happened today, not toward me, but toward my sister. But anyway, so then I feel like, oh, wow, I get to step back and take a deep breath about that's just their personality. That's just the way they communicate, but they're not necessarily attacking us. But without the training or without the round table, I would not have that kind of skill, right? But so yeah, it expands throughout my many, I would say probably a year now since I take that. If not, I've taken twice. So I so recommended that. It's been so helpful for many reasons. So thank you for the opportunity.
And then another dynamic we offer is understanding the other person, which is a huge part of the roundtable. And I'm just going to leave you with a little hashtag that we have for that roundtable, and that's it's more important to be interested versus being interesting. And so often people think good, healthy communications and to win your negotiations. And negotiation doesn't mean winning. It means getting to collaboration where both people walk away with something. And to get to that, it's about, well, if I talk and I get interesting and I get them interested in me, I'm going to get there, and it's quite the opposite. So we do talk a lot about that. And we're going to do role play in this new roundtable. I just added that. So thank you both for that. And I just wanted to get more people to be interested in that one because it's a super empowering roundtable. So, moving on, we have Brian who will be presenting today on the topic of court. And I'm assuming that many of you are either in court or considering court or have experience with court. Brian is a Canadian attorney whose practice focuses on cases involving high conflict divorce, denial of access, and parental alienation. Brian works as a special counsel with the U.S. and Canadian foreign attorneys and mental health professionals in the field of high conflict divorce and parental alienation. He has co-authored a book, The High Conflict Custody Battle, with Dr. Amy Baker and Dr. Michael Bone on related issues, which can be found on Amazon, Indigo, and other online book retailers. He's also a business and securities law attorney with over 32 years of experience and many years of experience with cross-border mergers, IPOs, and securities transactions. Brian is dedicated to sharing what he has learned from all of his clients and cases and from his own personal experience with professionals and targeted parents across North America. Brian is a frequent speaker in multiple media sources and has spoken for ISNAF, for PAAO and Children's Rights Council, the Canadian Equal Parenting Coalition, Family Access, frequently in its webinars, and gave 2 papers at the 2019 conference in Kentucky. Brian gave papers at the 2017 PASG conference in Washington, at the 2018 EAPAP conference in London, UK, and at the 2019 PASG conference in Philadelphia. Brian participated on the first edition of the Postgraduate Certificate in Parental Alienation Pioneering Course, University of Malta, in 2021 to 2022. Brian will be participating as a faculty member in the second edition of this course. In 2014, Brian participated with many of the leading North American mental health experts in parental alienation at a colloquium sponsored by ISNAF, the consensus statement from which will be published to help guide diagnosis and therapy and other interventions over the next decade, and it has been being utilized. Brian is a founding member of Lawyers for Shared Parenting and drafted much of the bill C-560, a 2014 proposal to amend Canada's Divorce Act to introduce a rebuttable presumption of equal shared parenting. Brian was an invited witness to the Canadian House of Commons in 2018 and Senate 2019 committee hearings on Bill C-78. Amendments to Canada's divorce legislation that took effect on March 2021, where he presented on equal parenting presumptions and the rationale for them. Brian is the legal editor of the PASG bi-monthly newsletter. The jurisprudence on many of Brian's cases have made meaningful advances in the legal remedies courts are directed to use in denial of access and parental alienation cases. He's working on a project to set the first worldwide standards for systemic family therapy. He continues to generate leading jurisprudence and consults on strategic counsel across North America.
Well, thank you so much, Cindy. It's been a pleasure knowing Cindy for well over a decade and a half. And Cindy, as you guys know, is tireless in her pursuit of solutions and her supporting parents going through this. It definitely takes a village to win this battle. So when Cindy and I were talking about what I might speak to, since I've spoken to ISNAF about a whole host of topics, what we came up with was, how can you prove what we call a PA case simply, succinctly, persuasively, early on in the case, well before the necessity of a trial, so that you can get parental coordinators on side, you can get therapists on side, you can get judges making meaningful orders early in the case. Because you might prevail at a trial 3 to 4 years in, but how much damage has been done to the children by that time? Things get a lot harder to turn around. And of course, it's a very long, arduous process, which is why it's so great that ISNAF offers all these supportive programs for parents and I guess grandparents going through it. But it's just not a satisfactory answer to just send all these very difficult cases to trial years away. We need faster, more expedient solutions early on in the post-separation family dynamic when things are not so entrenched that we can't turn it around. So speed is always important, and delay is frequently a tactic of the alienating parent. Now, in recent years, with Caden's Law and its California implementation, Peaky's Law, it's gotten a little bit harder because the models, the mental models, because there is no one universal diagnostic construct. There are several that have scientific validity if you follow the literature, which I do, but they're not universally accepted. And if you're really a student of this area, you'll know that there are various codes in the DSM that while they don't use the term PA effectively, or PA, child psychological abuse, for example. So there's lots of different conceptualizations that you could bring forward, not any of them completely definitive. So you could run your factual scenario through several of these models and say, well, it proves out that the primary causal factor is PA if you look at this model, this model, this model, this model. So that's pretty persuasive. But you may have to educate the judge who isn't familiar with any of the models. And all of this is taking place where there's another side to the case, playing the smoke and mirrors game, trying to advance an abuse narrative. And hence we get this manufactured controversy in trying to help these families. Is it abuse? Is it alienation? And to some extent, all of these binaries are too restrictive. It is rare that any one family having difficulty restructuring in a healthy manner ticks all the boxes so that it's beyond debate. There might be some kernel of truth to lots of different things. Alienators consider that a victory. A tie is as good as a win because if you don't have a finding of PA, you have a hybrid case is yet another buzzword that they use. Court's not going to make a meaningful intervention, and alienators don't care if they're yelled at or chastised by PCs, by therapists, by guardians ad litem, by judges. They don't care. You can't reach them that way. So it's a very unsatisfactory state of affairs if you're trying to get effective remedies in the midst of all of these factors. And in California and about 5 other states, you now face these additional hurdles of you can't get systemic family therapy, at least if you call it reunification therapy. And you can't get a reversal of primary residence, even though that's done all the time in the child protection world where there's child abuse. And you can't use the term PA. So it's very unsatisfactory, and for that reason, those restrictions, they're not going to last. It will be repealed at some point. In Canada, we had an attempt to introduce the same thing last year, which didn't go too far. And the same group, 250 feminist organizations, have banded together and have reintroduced it as a private member's bill, so not being advanced by the way our parliamentary system works, the party in power, the Liberal Party of Canada. But it is a Liberal backbencher who introduced it, and it has made it through second reading into committee. So a whole bunch of us in opposition to that bill will be heading up to Ottawa to make presentations to the Justice Committee studying this bill, and we hope to kill it there. We've got a big press campaign going on. We're very well organized. I was consulted and tried to assist in the California push, in Colorado, and in one or two other states. But by the time the local community got organized, there was too much momentum. And so you guys are facing this, and I hope that we don't face this. A journalist in one of our national papers, the National Post, who I've known for many years, she's a proponent of equal shared parenting, published an article in yesterday's National Post that has now gone viral, and it heavily quotes from me. And I want to show you guys, because the main purpose of this presentation is how to prove a case quickly and succinctly. And I'm going to show you how to do it without relying on the traditional terms of parental alienation and the traditional diagnostic. These factors in the child, these observable lists of behaviors of the favored parent, absence of demonstrable parental abuse. I'm going to show you how you can quickly make your point about what the primary causal factor is, because nothing is 100% pure. And I'm going to do that shortly, but I want to show you what can be done if you are well organized, if you do get the mainstream press on side. Okay, so it's a 2-page article, and those of you familiar with the California process that led to Pickey's Law, after a couple of your local mental health practitioners had defeated the first attempt the year before, we're into round 2 as well. And so the first thing is the rhetoric, because your pitch, and again, this is a pitch that's as important for parental coordinators, therapists, guardians ad litem. It's not just the pitch for the court. It's useful in all of these forums. You have to convince all those third parties that the primary causal factor is not severe parenting deficiencies on your part, but rather the children being manipulated, brainwashed, programmed, suggested, whatever term you want to use. The authentic child, as most of us know, is still there, hidden underneath. And the remedies help to surface the authentic child. But what the world sees, of course, is this disrespectful, nasty, rejecting child that doesn't look anything like the child we knew the child's whole life leading up to sometimes 6 months before. And that in and of itself is a practical tool in the diagnostic. So, the rhetoric. Just like in California, the groups, 250 feminist and left-wing sort of groups have signed on in support of this bill. So it's Bill C-223, which technically is in proposed statutory amendments to our Federal Divorce Act, and then the provinces would adapt their legislation accordingly. It's kind of dual jurisdiction in Canada. And they call it the Keeping Children Safe Act. But of course, if these changes go through, far from children being kept safe, children are going to be exposed to coercive control, family violence through the manipulation and brainwashing and teaching children to hate, etc. So it's how do you counter that rhetoric? They're trying to stake out the moral mountaintop. Who could be against a statute titled the Keeping Children Safe Act? Unless you're prepared to do the deep dive and try and really understand what's going on, most people who really don't follow family law, the vast bulk of members of the federal parliament, this is just not their area of interest, they're going to be persuaded almost by the title. We have to convince them to scratch beneath the surface. And so let's look at the tools that Barbara, the author here, who I've known for a very, very long time, uses to pick this thing apart after a very lengthy interview that she and I had. So the first thing is she does counter the rhetoric. Far from keeping children safe, the bill, if passed, will put many children in jeopardy while keeping their alienating parents safe. Ouch. That's going right for the heart. That's exactly what you need. Call it out. Secondly, and this is one of the tools still available in California, parental alienation is a brutal form of child abuse. So you guys can't use the term parental alienation. You guys can't use any of the scientifically validated assessment models. But in every jurisdiction around the world, for obvious reasons, one of the principal criteria is, are you a parent who is abusive to your own children or other people's children? So by defining the concept of PA, but we can't call it PA because the term is outlawed, so some colloquial understanding of manipulating children through coercive control to not like or not feel safe around the other parent and the other extended family, I mean, PA is just a label. All labels are conclusionary statements. It's just long and awkward to have to not use a label. But for purposes of avoiding PA, we're going to adopt child abuse, coercive control child abuse. That is still an argument. Preventing the child from having their own opinion about things, forcing the child to socially reference the meaning of things through the dominant parent, squashing any attempt at independence, having the child scared to voice any independent views, like, why can't I love my father also? Why can't I love my mother also? Why do I have to choose? None of that is allowed in the dominant household. To squash that, to basically say, you're my tool, is child abuse. It's also domestic violence or family violence. So those are actually modern terms brought into most legislation over the last 10 to 15 years. And those are available to be used to describe the same behavior, again, as a conclusionary label. You would have to explain to someone why squashing a child's independent view of things, independent voice, curiosity, demand to love both families, why is that family violence? Why is that child abuse? When you slap a conclusionary label on it, that job is done for you. So you have to, because you're avoiding that label and you want to slap a different label on it, you have to be prepared to teach. And you don't have to invent the teaching. There's lots of peer-reviewed journal materials and book chapters out there. The Parental Alienation Study Group has a library at Vanderbilt, where its founder, Bill Bernay, is a professor emeritus there, has over 1,300 individual items to draw from. There's too much material. So you can do it ultimately without using the term parental alienation. And Barbara goes on in this paragraph to attempt to do that. And then she takes on the latest reference. So the naysayers of what, as you can see from the article, over 22 million adults in the US know very well what this is that we're talking about, because they've experienced it. You'll hear conventional understanding of PA described as a belief system. Like, so it's not real. You won't find it in the real world. It's a construct. It's just a belief system. It's not real. And for anybody who's gone through it, myself included, it's real, and it's very unpleasant. So they're just out there saying the sky is pink, the sky is pink, when they know very well that the sky is blue. They just hope if they repeat it enough and they label it enough, it will lose following. Because on the whole, if you follow the jurisprudence over the last 20 to 40 years, they are losing. The weight of jurisprudence is so heavily in favor of an understanding of what this looks like. There's the diagnostic. And what you need to do about it. There's the remedies / orders requested. That they are really fighting an uphill battle. And so they have to obfuscate, lie, mislead the way the proponents of this type of legislation are known to do. Even the original source of Cadence Law, as an add-on to some other focused U.S. federal law proposal, and then this was just like a add-on. The assumptions and presumptions and basis for the remedy are all false. This is the work of Joan Ryan. And a lot has been written about why and how the foundational basis for Cadence Law is completely wrong. And it's up for renewal in a year, and the forces are gathering to make sure that it doesn't get renewed. So any of you who are interested in helping on the advocacy front, there's an area to jump in. There's a lawyer and psychologist out of Colorado who are also spearheading this. But if you contact PSG, they'll know who. There's a group of people involved in trying to contest the renewal of Cadence Law. There's a group involved in challenging through research, truth appeals.
Brian, excuse me for just a moment.
Sure.
Could you explain for those people who don't know what Cadence Law or Peque's Law is, could you briefly just give them a summary so that they can follow along a little bit easier?
Sure. As a matter of fact, what I'll do is I'll show, and I know where I can find it. And the reason why I'm showing you guys what's happening on the advocacy and legislative front is that the one positive thing about the challenge to the traditional way that we would prove a PA case is that it forces you to go back to the drawing board. Same problem, same goal. How can I nonetheless prove this using other language, other tools, and keep it short, sweet, and succinct? And so to some extent, where I seek to help people in California and some of these other states, and God forbid I also have to deal with this in Canada, it can be done. And I'm going to show you guys how in a sec. Here you are. And of course, we are a bilingual country, so you have it in English and French. So it's not a standalone piece of legislation. It's a piece of legislation, just like Peque's Law was, that amends an existing statute, in our case, the Federal Divorce Act. So here's the background summary. And you can see that the focus is, and we just amended all our laws in 2019 to really up the ante on domestic violence assessment in the course of parenting plans. But here they are again, wanting to assess the impact of coercive control on parent-child relationships so as to ensure children are protected from domestic violence. But there's the pot calling the kettle black, because the proponents of this bill are seeking to restrict findings and remedies about PA, which is coercive control. So it really is the pot calling the kettle black. And they say, oh, we should hear from children directly. We should have more judicial interviews, something that is usually frowned upon by judges. They need to be an adjudicator and not be drawn into the fray. And there's guidance that does exist for judicial interviews, how they're done, how it should be structured, that is completely missing from this bill. And then they say, address certain myths and stereotypes. And that's where they go right at the heart to try and create an unlevel playing field. Any allegation of abuse, you're guilty until proven innocent. And if you're absolved of it in the criminal system, even short of a trial, even if the charges are quickly dropped, or in the child protection system, you can't use that. You can't defend yourself from the allegations. Say, well, it was fully investigated by the child protection authorities. They didn't find anything. Not allowed. But the parent making false allegations is allowed to say this person was charged. And you can't respond to say there was nothing there. The charges were dropped after a month unconditionally. Unlevel playing field. It's really diabolical. Okay, so let's show you what's so upsetting about this bill. Okay, here we are. So it's amending the Divorce Act. And I'll move past some of the technical changes. So here they are putting the lawyer for the parent alleging abuse in a tough position of now the lawyer has a statutory duty, takes you out of your duty to your regulator, your duty to the court. You have an independent duty to put in place a safety plan. So what are you supposed to do if your client is saying, oh, the mother's really abusive, I can't send the child there? Do you have to implement a safety plan because your client is telling you it's unsafe to send the child to the other parent when there's a court order? How does a lawyer reconcile all these conflicting duties? Duty to the court, duty to your regulator, duty to your client, duty under the statute. It's almost irreconcilable. Then they want to stick taking into account family violence everywhere. So 16 sub 3 of our Divorce Act is our friendly parent principle. That one of the factors we look at is the ability and willingness of a parent to support the children's relationship with the other parent. It's not who smiles the nicest, it's who can be the most supportive of the children's relationship with the other parent. And that's been a cornerstone of our law since our modern divorce legislation came in 1986. Now, taking into consideration any evidence of family violence. So there was family violence of some sort 15 years before, and then the family separates, so you don't have to promote the parent to the children? And what degree of family violence, and what frequency of family violence, and what type of family violence? You said, we need a budget. We're not saving for our retirement. We need a budget. We're implementing spending limits. Well, that's financial coercive control, an aspect of family violence. So because you were the fiscally prudent parent, the other parent apparently doesn't have to promote you to the children. One has nothing to do with the other. Now you'd have to see some of the sections they're taking out. So look at factor not to be considered. Court shall not take into consideration any allegation that a spouse has or is likely to, through deliberate manipulation, persuade or encourage a child to become estranged from or resist contact with the other spouse. So you're not allowed to make the argument anymore. They give a half-hearted exception in what follows in 3.2. But they have taken away. Notice they didn't use the term PA. They want to take away the factual assertion that one parent is hurting the other parent's relationship with the children. It's breathtaking in its maliciousness and potential to do harm. Okay. We have a principle that the past is prologue, not necessarily. So in other words, issues of the past are relevant only if it is likely that they will repeat and are directly relevant to the well-being of the children. Now, if you have engaged in any sort of family violence, no matter how infrequently, no matter what type, no matter what circumstances, you have to demonstrate that you have changed and there's no risk. So they've completely flipped the emphasis. Then they have their myths and stereotypes section. You can no longer say, well, the parties are separate, so there just won't be situations that will trigger situational couple violence. Can't do that anymore. You can't say that prior to separation, the child protection authorities, the police, had never heard of this family. That this rush of allegations only happens post-separation. There's meaning to that. Can't say that. Police investigated, child protection authorities investigated, nobody found anything that's meaningful. Can't say that. That's now a myth. Allegations are coming out of the woodwork now that were never made before. And there were positive statements made before. So the whole story conflicts and is inconsistent with the reality that everybody lived. Can't say that. Allegations are made in the family law case that don't fit allegations made elsewhere. So the alleging parent is either grossly mistaken or lying in one of the two or both forms. Can't say that anymore. So they're removing some of the key evidence-based forensic tools that we use to distinguish false allegations from allegations that have some degree of merit to them. Parenting time, no presumption. We don't have a presumption of equal parenting, but we have a maximum contact principle. All other things being equal, courts should inquire as to whether maximizing time with both parents is a good thing for the child. It's a mandatory inquiry. Now, it's very clear that they want to get rid of the maximum contact principle. Then they want to make judicial interviews, which are frowned upon in comparison to other methods of getting the voice of the child before the court. They want to make it maybe the primary way we get the voice of the child. And as I said, judicial interviews are rarely done. And there's a guidance book for judges as to how they are done, if they are done. Most judges don't want to do it because they understand that it could compromise their ability to adjudicate objectively. They get drawn down into the weeds. You don't want the judge going to visit the parents and see how they parent firsthand. It's turning the judge into a witness. So, but what they want is they count on manipulated kids going in to tell a judge all kinds of bad things so that it colors the judge's view of the targeted parent. And you don't even know what the child's telling the judge. Here's the disclosure section. Then remedies, if despite all of those hurdles, a judge is somehow able to figure out that the primary causal factor in a particular family's distress is what we colloquially call PA, they take away the two biggest tools to deal with it. You can't restrict parenting time. You can't require a child or a parent to participate in reunification therapy. Then they even make relocation just where there's allegations of PA easier. So suffice it to say, because I do want to get back to how to prove a case quickly and succinctly, but your Peaky's law in California does very similar harm. it does other things. These are not copies of each other, but you get the thrust of what it is that we are so concerned about here, and that to a large extent in California, it's already there.
Brian, if I could interject, it's Peque's Law. It's also known as Caden's Law, and in some other states, they're passing it as Kim's Law. And I believe last I heard, I think they had passed that similar law in about 9 states, California being one of them about 2 years ago. We have several people from other states, so you need to look it up for your state. Just wanted to give you that. Thank you.
Okay. So now the wind has gone out of the sails a little bit in the states, in that there was a rush of state after state after state, with the same group of rabble rousers, like a convoy going from state to try and convince state legislatures this was urgently needed. Seems to have slowed down a bit because the family law community, including academics, therapists, lawyers, have kind of woken up and said, oh, we got a problem on our hands here. So it's just that the proponents of this were better organized at first, but I think 10 years from now, for sure, you'll see all of these add-ons being repealed. But obviously, it's a lot better to prevent it in the first place. So what I'm now going to turn to, now that you guys see the problem, you can't just walk in and say, here's the model that Dr. Gardner came up with that has been embellished and scientifically validated by the late Dr. Doug Darnell and Dr. Amy Baker out of New York and many others. It's now called the 5-factor model. You're going to have a tough time, not just in the courts of California, but increasingly in England, where the experienced practitioners, they've dropped the term PA entirely. So how are we going to do it? It forces us to up our game. How are we going to succinctly and without using traditional models? Here's the model. There's thousands and thousands of cases using this model, and my fact patterns fit that model, and therefore I've got a PA case. That straightforward path, certainly in California, but also when you're dealing with a less experienced PC, a less experienced guardian ad litem, a less experienced therapist, that sort of argument isn't going to work with them either. So is there a more practical, expedient way? So as it turns out, I'm a frequent speaker for equal shared parenting groups, and I was challenged by one just a great academic out of University of Guelph here in Ontario, who's established a whole organization, puts on annual conferences, books, academic research, etc. She's a tremendous, tireless worker in the field, Professor Susan Chuang. And so she challenged me to prove a PA case in 15 minutes or less. Okay, here we go. So you start off with challenging the court that the scientific literature is so robust about what lies ahead for these children as young adults when they come to terms with the losses of their childhood, loss of a normal childhood, loss of a parent, loss of an extended family, stuck in the vortex, being made to do and say reprehensible things. Then they hit their 20s, they're a little bit independent, they're not living at home anymore, and the guilt and recriminations and sense of loss hits them like a tidal wave. And we have really good scientific literature, really robust experiential data that shows what lies ahead for those kids is shockingly bad. And this research goes all the way back to some of Dr. Baker's initial work in the 90s. So in effect, you are scaring the judge, the parental coordinator, the guardian ad litem, the therapist, that if this isn't fixed, whatever this is, whatever relative percentage of fault between the two parents, doesn't really matter at this point. We have a limited window. It must be fixed. Everybody's got to change. Child has to change because child's behavior is out of line, disrespectful, not observing normal interpersonal boundaries. Favored parent, lots of change needed. Rejected parent, change needed. If everybody commits to a new family constitution informed by the past, but not anchored on the past, miracles can happen. And failure is not an option. Now, where did I get that line from? If anybody's seen the movie Apollo 13 with Ed Harris in the role of the flight director, after the mishap in space, and they hadn't planned for that, they didn't have a manual about how to recover from an oxygen tank exploding in space, he challenged his engineering teams. Figure it out. Because failure's not an option. Failure means loss of crew. And loss of crew was not going to happen on his watch. Wouldn't it be great, because I'm sure none of you have actually experienced this, if every person involved, including the lawyers, were directed that because of the pending inevitable harm to the children, this must be solved. Period. So if instead of a statute putting lawyers in the middle, saying if there's any concern at all, like even if it's completely unjustified, about domestic violence, so where's that concern going to come from? The alienating parent. It's always the battle between abuse as the primary cause of the children not wanting to see a parent versus alienation. And as I said before, it's rarely that simple binary. But this statute that I showed you is not telling lawyers, fix this. It's telling them the opposite. You're obligated. You're not the Children's Aid Society, but we're putting the burden on you to put in place a safety plan. Well, what's the safety plan? Other than the children shouldn't have to see the other parent. It's just some fancy language that the alienators can hide behind. A safety plan. What does that mean? Other than you have a concern, don't send the children. You're a protective parent, and not sending the children, despite a court order, is your safety plan. Lawyers are obligated to put in place safety plans. So now they're not just advisors anymore, they have a duty. It's not well thought out. But if you can scare the judge, scare the other participants about what inevitably lies ahead, and if anybody's interested, I've I've got the best of that literature that I could send you. Point 2. There is zero science supporting the aspirational statement that if you just stop litigating, if you take the pressure off, if you give the child some space, they'll come around. Just stop litigating. The child just wants the litigation to be over. And we're not going to force the child into therapy. We're not going to force the child to see you. Just leave it alone. It's all going to work out. Well, that's an aspirational statement. That is not a statement that is backed up by surveys or formal science that we know of. And yet, you'll hear that. And so you just have to jump all over it and kill it, because there's no there. It's simply untrue. Then you'll have the old, oh, it's a mature minor. A 16-year-old can walk with their feet. There's nothing we can do. Well, hogwash. You're building the young adult, giving them the tools for their life. To just give up and allow children to act this way is setting them up for failure in their life. Forget about the age. I don't care if they're 17 years and 11 months. It's not too late to get some good work done that will position them well for the future. And then the last point is challenging the participants to get into solution mode. Stop creating problems, stop creating controversy or divisiveness. Solve it quickly. So if you orient people on these 4 themes, you're past all the technical requirements and everything we saw in the proposed legislative change and all the historical models. Here it is. You got a limited runway. Fix this. Everybody be nice. Everybody be supportive. Kill the false narratives. Kill anything that's undermining relationships. Dive into some systemic family therapy. Be moral. Be empathetic. Be respectful. Solve this, which is, by definition, in the best interest of the children. There it is. Get people anchored on your framing this in a solution-focused way. Secondly, you are going to need a diagnostic, but the diagnostic is not, this is a pure PA case, this is a pure estrangement case, this is a pure anything. You're looking for the primary causal factor. What I call the but-for test. But for dynamic X in this family system, we'd have success. Targeted parent, you're a little bit rough around the edges. We're going to work with you. You're highly motivated, obviously, to fix this. That's not the problem here. It's standing in the way. It's making things more difficult, but that's not the problem. Because your child loved you despite all of that throughout the child's life. So that's not the cause of this. But we're going to sand off those rough edges, give you some tips, throw a parenting coach at you. You're going to read. I have a parenting library here of some 300 books. We're going to pick some selected books for you to read, shine you up as a parent. your kid will be happier for it. But you didn't cause this. You just set the kindling on the forest floor. The other parent brought the gasoline and the matches. Okay. So we still need some sort of construct for what PA means. We need a construct for gatekeeping. Children are mine. I decide how much you see them. No, children are not property. Children are free agents. No parent decides anything. Also because they're conflicted. You can describe the enmeshment as a psychological alliance or a loyalty bind, similar to what the family systems theorists of the 70s and 80s were writing about, Bowen, Mnuchin, Haley, etc., which is considered part of mainstream psychology. So beyond controversy over does PA exist or not. The misinformation piece you get by if you anchor on those themes on the first page. You have to make sure that everybody understands just how vulnerable and therefore suggestible a child caught in the middle is. And you also need to know the basics of memory science. How does memory work? Can a child somehow recall a whole bunch of details of some alleged abusive parenting from when the child was 4 years old? Answer, no. Can you remember more details about something from the past over time? Generally, no. Is there such a thing as recovered memory? You have no memory of it, and then it all springs back to life in all its glorious detail? Generally, no. A lot has been written about memory. I have a whole library here on memory science, but a very accessible publication was published by the research arm of the British Psychological Association around 2009, focused on what is the understanding of memory that is so settled, so beyond controversy, that members of the British Psychological Association, when they're called upon to be experts in court, can speak to that construct as being fully evidence-based. So they have a publication out, it's about 50 pages, with an executive summary on the front end that tells you what the accepted science of memory is. And we've had a lot more written about memory science over the last 10 years, but it became a thing, an area of interest, because of the recovered memory scandal of the 70s to 80s. And Professor Elizabeth Loftus, who debunked that whole thing. But many, many families were destroyed when that became all the rage, recovered memories, which we now understand to a large extent can't happen. So you need to know that, because you're going to be dealing with all kinds of false allegations, and there's forensic approaches to refuting it, but you have to know what's possible, what's not possible, because the not possible means there's programming going on. And you have to make sure that the others, who will generally have no knowledge about memory science whatsoever, that they understand that. And there is a law of memory science as well, by the way. Okay, I've said a lot about labels. Can you prove this case without labels? Well, one of my earliest well-known cases, as early as 2011, said, like the Mexican bandit in Blazing Saddles, who famously said, "Bodges, we don't need no stinking bodges." So, same sort of thought process. You actually don't need a label. Conceptually, manipulating a child to dislike or fear the other parent is emotional abuse, emotional harm, well understood as part of the private custody and access litigation as well as child protection standards. Or you go to another one of my cases, AM versus CH, Ontario Court of Appeal 2019, where some really, really important controversies in the law were settled. But for today's purposes, PA and its remedies are simply factual inquiries. You don't need an expert pronouncing on the synthesized result of what the primary causal factor is. You bring your case, you prove your case, it's well within the wheelhouse of an experienced family court judge. So that simplifies things, then you don't have the battle of the experts, and it's cheaper. A lot of families can't afford to bring in experts. Our law here in Ontario, Canada, got to the point where, in a case where I wasn't counsel of record, but I was assisting the counsel of record, D versus T, in the Ontario Court of Appeal in 22, but I'm focusing on the Superior Court case in 21, where a well-known judge turned down the availability of one of Canada's leading experts on PA to just explain how it works to the court, not case specific. And Justice Conlon said, I don't need that. I know what PA is, and I'm prepared to take judicial notice of it. Judicial notice means it's taken as a given, it cannot be contested, it is simply recognized as what is. So we've reached, you can't go further than that in terms of the recognition of what we colloquially call PA. And this proposed, we also have lots of case law equating PA with emotional abuse, emotional harm. This proposed legislation would run completely contrary to our settled law. And the last point here, if instead of the typical labels, you compiled your list, brought your witnesses and your documents, and you proved out a list of helpful behavior, unhelpful behavior, and requests for helpful behavior that were ignored or denied, you'd be within the wheelhouse of a judge. And when the judge parses all of that, the judge will say, Parent A is not meeting the needs of the children. Children need both parents. The legislation that I'm showing you basically says that's what we always understood, that kids need both parents and courts should strive to maximize the parenting plans. Oh, but I guess that was wrong. We're not going to be doing that anymore. And trying to manipulate a child against the other parent, which we always understood was unhelpful behavior, I guess we can't call it that. We have to reconceptualize it. So you see the problems with the legislation, but these concepts, helpful, unhelpful, denials or ignoring, lists of requested helpful behavior, I don't think they can legislate out of existence. It's just too fundamental to what the court is doing in the first place. So that's another way you can get around. And for dealing with the parental coordinators, therapists, guardians, etc., who may not understand or even agree with standard PA methodology, compiling it this way, anybody can understand. So then you get to the remedy. And of course, these legislative changes are saying you can't force unwilling participants into systemic family therapy, whatever you call it. You can't use parenting time to protect the children from the abuse of PA. So we were always faced with a stark dilemma because usually alienating parents are not following court orders anyway. So you can't just solve this with another court order, increase the parenting time to 50-50 and hope everybody plays ball, because generally the alienating parent is not even complying with a lesser court order. So the remedies part of this, even though it's easy to prove this out, even with the loss of use of historical constructs and labels, you kind of hit a brick wall on the remedy side if they're going to take away the two principal remedies. I've heard from some lawyers in California, for example, that some judges, with the assistance of lawyers, are getting very creative and finding ways to actually really intervene seriously in these families, even without the historical remedies. But you have to find a lawyer who's really good and really creative. If anybody is looking for a local California lawyer, give me a call. And some of the broader concerns I've got on this slide here, just inconsistencies within the constructs and the dialogues that we're dealing with in these very difficult cases. So a little bit off topic of what we're focusing on. And there you are. So you can prove out a case in 15 minutes or less by just sticking to core bedrock principles and avoiding the use of labels or use labels that are still allowed. And it can be done. But you start off with scaring everybody about what lies ahead if the problem isn't solved. Because if you can get everybody locked in on that, there must be a solution, because it's too dire to contemplate what happens if there isn't a solution. Then you're likely going to get a positive answer.
Well, thank you, Brian. Excellent presentation. I would like to say it's wonderful to have that slide presentation showing that, and where so many parents, including myself, way back when, were stuck with trying to prove the theory of parental alienation, which wasn't even in the DSM way back when, and spinning our wheels trying to have it's almost like having a grammatical conversation in an area that they just don't accept that, and then there's all the other opposing arguments. And instead, across the United States, the standard is best interest of the child. And if you could start showing here's the impact to the child, it only makes sense. Let's just argue for helping this child. This is a dire situation. We're not going to leave this child here to fail in their future. And instead of pointing out all of the science and getting stuck with the languaging and all of that, keep pointing to the best interests of the child and what is occurring for the child. So thank you for packaging that. Brian's email is brian at ludmer, Ludmer, law.com. So if you want to connect with Brian, and I think we might have a couple people interested in lawyers in California who have some knowledge, including myself. I have parents all the time seeking lawyers, and I only know of a couple. The other question I have to you, Brian, is one of the challenges for many of ISNAF parents is they come to support groups, and where by the time people seek support, they're probably pretty much drained and emotionally, physically lost their children, or they're on a thread, and financially. So, what is the average rate that you know of that people can expect to be paying for a good PA attorney? Just out of curiosity.
Very hard for me to speculate because it will vary by municipality. And there are so few attorneys who really, really understand this dynamic. What I often suggest to people is get a good, solid family law attorney and hire some additional expertise just for the PA overlay. And that could be somebody like Cindy. It could be a mental health practitioner who's testified as an expert. Could be another lawyer. Could be me. I do this all over North America. There are so many municipalities where you're just not going to find a large group of capable lawyers.
A one-stop shop, correct?
Yeah. So and if you do find somebody who's an experienced family law litigator and has a lot of experience in this area, they're not going to be cheap. So there are times where you want to broaden out who you might be able to retain, and then you supplement that with somebody whose mandate is going to be solely to add this piece of it, this construct, this knowledge to what is otherwise just a custody dispute with overtones of child abuse and false allegations, which your run-of-the-mill family law case has false allegations and battles and that sort of thing. So that's what I would urge people to do. You could get access to a database of reported cases in California, for example, and look for lawyers who successfully acted for targeted parents.
Well, just
that's another way to
curious,
do it.
how would you know they were successful by getting a database? Where would you go for that? Just
Well, I mean, there are commercial databases. There's some public databases. There, in Canada, this jurisprudence is much more accessible. But Westlaw, for example, and if you research California cases where there were allegations of PA, find cases where a court found PA, who was the lawyer who acted for the targeted parent in that case. They likely know what they were doing.
and do they actually give case numbers that they can go on and look at cases? I never really knew that was available.
Yeah, in the commercial databases for cases, you'll you'll have the parties. It won't, it will have a court file number, but you're just looking for a case where somebody successfully proved PA and who was the lawyer. The decisions always indicate who the lawyer for the plaintiff, who the lawyer for the defendant was. And so then you just look up that name.
Right. Okay, so now that I have that, this is just a resource. I have a few parents self-represented. So if now we know we can go to Westlaw, we can look up by the case, find the lawyers with the word PA. Could you find a PA case and then categorize it to where there were enmeshment findings, and what case was that? And you could look at how they were pleading that case. How could you do that through Westlaw as well?
Oh yeah, you could. It's very powerful search tools, and Westlaw, all of the providers are introducing AI now, which makes it
Right.
easier to search rather than just the old style Boolean searches. But if you were to search the word enmeshment in family law cases in California, you'd get some pretty good hits right off the bat.
Right, exactly. Now, with part of what you were showing, and I'm saying this because we really don't have any more questions. So if anybody has a question, I have questions myself, so I will take this opportunity. In saying that, what of the areas in your presentation, now I'm changing subjects here. So you spoke about that we want to get a remedy to help this child. And then we're going but for, and the but for was about the targeted parent and something they might be doing that's anchoring the alienation. But how does that apply to they're trying to get a solution, but for the aligned parent continues to sabotage all of the therapeutic process, and there have been enmeshment findings in this particular case. So what do you do with that? And
Okay, so the but for construct is just a logical way of sorting through all the different errors and behaviors that might be problematic, some on the part of the favored parent, some on the part of the targeted parent. And if you could say that but for what the alienating parent is doing, the targeted parent would still have a good relationship with the children. Their parenting deficiencies, such as they are solvable, resolvable. 5 sessions with a parenting coach will have that solved. Or sure, that wasn't optimal, but that didn't lead to the destruction of this relationship. Had to have been something else. But for that something else, even with these errors and this bad day and these parenting deficiencies, there'd still be a normal relationship. That's what the but for test is.
okay.
It's a way to minimize in the overall diagnostic the emphasis put on alleged errors of the targeted parent.
Okay.
Now,
Yeah.
if you mentioned, Cindy, what if the favored parent is like sabotaging the therapy? So when you were introducing me, you mentioned that I'm working with several leading international therapists, and this is a well-funded project by somebody who's taken a real interest in this area, to come up with the first set of international standards for the conduct of systemic family therapy for broken families. And it's almost incomprehensible to recognize that this project is necessary because the standard of practice is so bad that the vast majority of these interventions fail, and yet it's one of the few tools we have. And that's just not acceptable. The layman's definition of insanity is doing the same thing over and over again, hoping for a better result. So we're supposed to be learning from our failures and baking in that knowledge so that the next time systemic family is used, it's more robust. And so that's what this project is all about. As it turns out, the number one cause of failure of these systemic family therapy interventions is not poor design, poor input. It was undermined. You can expect, though, that the favored parent and the children who are not willing participants are gonna undermine it. They don't want to be there. And the whole premise of what we conventionally call therapy is that the patient wants to be there, is seeking help, will let down their guard and take the suggestions to heart and work with the therapist toward a common goal. And that is the basis for the therapeutic alliance in conventional therapeutic relationships. But that's all missing in these cases. What's needed is a much more directive process, which is not standard therapy. And the reason why it has to be directive is that 2 of the 3 participants, the favored parent and the children, don't want to be there, don't want to change, aren't invested in the happy ending. So of course it fails miserably the vast majority of the time. Well, that's unacceptable. You can anticipate this. So what are we going to do to design around it, knowing that they're not motivated? We have to create artificial motivation through accountability, which goes into the whole design and the court orders supporting the therapy, the therapeutic contracts, the frequent reporting into the court, and accountability. The pacing of it, very important. And so we're working on a worldwide survey of best practices, poor practices, scientific literature, experiential literature, and we're going to come up with a set of worldwide standards for this.
A standardization would be amazing. And then we can start seeing much more consistency in the impact. So just to sum up what you just shared right there, along with your share of this evening. So instead of trying to focus on the 5 dynamics, I'm probably saying it wrong, of alienation, and here's the specifics, it's focusing on here's the impact to the child, and what are the solutions, and let's get there. And so you're taking out the language or the conversation in between and just say, this is happening and we need a solution and we need it quickly and let's move there.
Very, very much so. And you look, so the rules of the game for the family moving forward, since it's unable to restructure in a healthy way in and of itself, are very important, highly detailed, highly prescriptive, future focused. Leave the past in the past. Forgiveness, spirituality, morality, empathy. It's like you're creating a playbook.
Meet them where they are and then create something new to move forward into for everyone. Right. Correct.
Okay, but people have to stop anchoring on the narratives of the past narratives yield power. And so the favorite parent and the children, they're going to hang on to those narratives, and they're unforgivable. Whatever perceived or invented slights of the targeted parent are unforgivable. And you must prostrate yourself and apologize and apologize. But if you do that, then they say, aha, I told you that you were abusive, and now you've admitted that you were abusive, so I never want to see you again. And you can't
Right,
back
so
off because you just, so they
so
force an
that becomes the
apology.
tornado that you walk into. So I want everybody to see it is never go there, because you're going, as soon as you go into the past and try to clarify that and justify it and bring out the true reality of what you see it as, you just walked into a tornado. Never go there. You have to have that. No. Why would you walk into a tornado? You have to have it. No, not going there. Let's start from where we are. What can we do moving forward? And you'll never ever get anywhere. But that's where you sink everything. The minute you go in the past, you waste all your time and money, and the child will age out in the process inside the tornado. And everybody will leave feeling badly. So let's move on to, we now suddenly have all these questions. So I have, if we represent ourselves, can we use the 15-minute pitch as an anchor in our case? I'm going to just say it's a very good outline. This particular parent is very new to the community, but anything else you want to add to that, Brian? There's a lot more to still work with, but go ahead.
In every case, even if somebody does have an attorney, they are their own principal advocate in all these forums, the PC forum, meeting with the guardian ad litem, meeting with the therapist. They're their own advocate in those forums. So, of course, everything here is not just for you to share with an attorney if you can afford the attorney. It's meant to educate the people and guide them in their direct dealings with these other players in those processes that are so important to getting a quick, expedient, satisfactory result.
Yeah, and to that point, what Brian is saying there for, and I know some of you are way beyond this, but I do want to say, because I know we have a few people who are new to the whole process. The thing Brian is saying there is, and I'm going to just give an analogy of it, is do you hire an employee to your company and then just let them come and run the company however they want? Or do you have a knowledge and a system and know what you need to do to run that company, and you train them and you supervise them and you watch them to make sure they're doing the proper thing? Even if you hire a manager or a vice president, that's who you need to be, is the owner of that company, and they're taking care of your, best, your most valued asset, and you need to be knowledgeable about it, manage it, observe it, and take it in the direction you need to, not just here you go, have at it, and then they bankrupt your company. Because that happens a lot, by the way. And just to give it a different analogy. Okay, next question. I heard the courts don't necessarily read all details of a case. What's the best way to present evidence without overwhelming the court with so much information?
Okay. Great question, by the way. Effective use of synthesized summaries with reference over to more detailed schedules and exhibits. Let's say you want to make a point that the other parent belittles you in the presence of the child whenever they get the chance. You'd make that point. You would give the 4 best examples. And then you would say, incidents like these 4 that I've described, in my experience, have happened at least 3 times a month for the last 3 years, and are noticeably having an effect on how my child looks at me. Constant belittling, chipping away at the respect and admiration that my child used to have for me. Just chip away, chip away, chip away. So you've explained that it's not just situational. You've explained that it's a pattern of behavior, but you haven't thrown 20 pages at it. If you really want to make your point, you would say that I have all the details of all the other incidents because I've been carefully documenting everything as I've been taught. The dates on which these incidents occurred over the last 3 years are, here's the list. What happened in the course of belittling me, I've got that, but it will overwhelm the reader. But I've given the 4 best examples, and I've told you how frequently it occurs, and here's the dates on which they occurred, and yes, I could describe what occurred on each of those dates. So now you haven't overwhelmed the reader, but you've really made your point that there's a pattern of behavior of continual belittling you to the child.
Okay, so if I could add to that, Brian, something that we do, and I'm just going to go to Brian has talked about working with a team. Dr. Stephen Miller wrote about that in the white paper from the colloquium. And that has been highly successful. And I've worked with Brian on a few teams as well, where you have the attorney doing the legal work in the state. Then you have Brian who's giving the strategy from the legal side of a PA case. And then I come in as coach and I'm working with the parent on day to day, like what do you say, what do you do on the little day to day minutia things that you don't need to spend $500 an hour to talk to your attorney about. And the therapists are able to coach you on that. But anyway, moving forward on that. So one of the things that I work with parents on and highly recommend creating a spreadsheet. Okay. You create a spreadsheet utilizing Amy Baker's 17 strategies of alienation, and you categorize across the top all of those, each of the 17 categories, and then you go through all of your communications with the other parent, your emails, and you list them by date. Put the oldest first, or it doesn't matter because you can filter it however you want. Just list all of your emails and then check the box of which 17 strategy does it apply to, and you'll very easily see which one is the bulk of whatever you have. Pick your top 4. I have 105 over here, and I have 52 here, and I have 4 here. Talk about those. And then you can utilize that spreadsheet to help you do analyses to know how do I go. And the other area you can work on, begin with the spreadsheet, and then once you have your spreadsheet, you can do a timeline, and then you can categorize your timeline. And we've done timelines by year. And if you're just presenting the last 3 months, we've done it by month, to categorize and summarize over the course and give over the course of the last 30 days, I have been denied access to my children, 52 times, and whatever that is, and you can work right off the worksheet to do the timeline is kind of the summary of the spreadsheet. Hopefully that helps. And if you don't know how to do a spreadsheet, you can probably find somebody out there to do that. The other thing that we've discovered, and be cautious about it, but there are services out there that will do paralegal work for you if you're representing yourself, and they'll kind of do some of that legwork, but they're not PA experts. You just need a PA person, and then you need to manage them, kind of like what I said about the company. Next question. It's interesting to hear Brian say that a rejecting parent, 16-year-old, is still reachable. Most people that I've listened to in PA say to give a teenager space. Let them know that you're there, but the child needs to lead interest in reunification. And I don't know who you're talking to in the PA community, so and what level they're at, and if you're in court or you're done with court, and those are all very personal decisions. But go ahead, Brian.
Okay, so Dr. Warshak, in his famous book, Divorce Poison, I think it's chapter 7, is all about where you realize nothing's going to work and you just have to suspend your efforts because you've been running into a brick wall, but you don't want to just disappear. You don't want the child to think that you're not interested, so you have to have this very difficult structured meeting where you say, exactly what Cindy just said. I'm open. I will count every day, but at this point, I have to just leave it to you. I can't keep pushing like this anymore. Sure, there comes a time where you have to do that, but not at 16. Not when court orders still apply. We know from our cognitive neuroscience that the teenage brain is not fully mature till 24 and a half. That's the final piece, the prefrontal cortex, which is the general for rational thinking. Teenagers, we all know, make notoriously poor decisions with lifelong ramifications. When you give up on a child at age 16, then they have another year or two, they finish high school, they go off to some university somewhere, they get swept up in all of that, boyfriend, girlfriend. Where's the connection going to come from? If a child doesn't exit childhood with a bonded relationship with a parent, is it merely aspirational to say, oh, don't worry, I'm sure they'll reconnect with you in future? It has not been my experience that that's a good plan, and I know from speaking with everybody in the field that occasionally you see these something acts as a catalyst. A young adult is going to get married, and their new partner says, it's not right that your mother's not there. We should really reach out. But it's just situational. It doesn't happen very frequently. Usually the people just drift apart, and you may not even know what city your child is going to university in. So it's just not my experience that giving up at age 16 makes a lot of sense.
Well, could I just interject there, Brian? Because I work with a lot of parents, and I am one of those parents from a long time ago. So please don't take anything I'm saying personal. It's just another insight. Sometimes parents run out of money and they have severe PTSD and they no longer can be in that court battle. And they can't self-represent because of the PTSD, and they don't have the financial resources, and they've gone through their retirement and they're living at home with their parents by this time. And that's when we have to resort to just what can I do and look at, because I think it is important. I want to make sure I say this for parents because I don't want to make you wrong and make you feel like, oh my God, I need to figure out something and make you wrong. It's important to pursue our children, and I worked with Dr. Miller on this in my own case with my own children to the very end. But it's also important to recognize your capacity, and you can only do what you are emotionally and financially able to do, and then you have to let go and let God, and still don't give up. The key here is not to give up, and that's all I'm going to say. If you have anything to add to that, Brian, please go ahead.
No, I mean, obviously my answer presupposes that the parent still has some contest left in them. But
Right.
in the scenario that you gave, then there's really not a lot to talk about. You've given it your all. Your conscience is clean. One day, if you can reconnect with your child, you will literally be able to say, I left it all on the floor. And that's important for the targeted parent's own self-conscious sense. But also, one day they may be having that conversation with their child. If their child stumbles on Maddie Wilburn's website, the Anti-Alienation Project, starts to see what things look like on the other side, and reaches out to reconnect, and says, as this is Amy Baker's foundational research that I was referring to, why did you give up? The one common thing that these young adults told Amy, I didn't want my mom/dad to ever give up. I know I was pushing them away. I know I was terrible to them. But I trusted that they would see through that I'm stuck in the middle playing a game, that my behavior is performative, not real. Yeah. And it was devastating to me when they gave up. So this is what the young adults are saying. But if you've left it all on the floor, you've gotten to the point where you're just exhausted as a person, your psyche, you have no money left, then that's fine. Your kids will accept that in future when they...
And the key there, Brian, I want to add to, thank you for that, is we give it every bit of, everything we can with the most capacity and ability that we can, but we never stop. We still love them, and then we find other avenues to continue to reach out. And yes, Amy Baker did say that. And children told parents, get out of my life, go away, drop dead. I hope I never want to see you again. And then they said in her book, her first book, Breaking the Ties That Bind, they secretly wish that the parent never went away. So as long as you recognize, I will do everything I can to the best of my ability, the best that I can, and I will never give up, then you do what you can, the best that you can, and that will be good enough. Because it has to be. And it doesn't mean, and we have lots of parents who still reconnect, but sometimes we have to let go of that. The legal process is the only process, and you can, I beat myself up and aged out both my kids in it, and ended up with huge financial, and only about 4 years ago did I get myself out of the financial debt I had in that. But do what you can. So let's move on to the next question. How many times of attempts or how long to get the other party to obey court orders before asking the judge to consider sanctions or fines and damages?
Okay, so what is available in most jurisdictions is something called a non-compliance motion. So it's not the quasi-criminal remedy of contempt, but it is variously phrased in different procedural rules across North America as a non-compliance motion. And you would bring it the first time seeking, say, makeup time, costs, and maybe some ancillary orders to deal with the conflicting narratives. The most important part of a non-compliance motion is ending the battle of the conflicting narratives, because the defending party is not just saying, yeah, I was wrong. They're saying, I did everything I could. The mother is a totally useless, poor excuse for a parent, abusive, etc., but I did encourage the kids to go. I did respect the court order. I understand why the kids didn't go, because this mother is a train wreck, but I did encourage them to go, so I'm not at fault. And of course, that's wrong, and the case law doesn't support that. The word encourage is completely vacuous. You have to demonstrate guidance, boundaries, incentives, and consequences. And if you're prepared to pitch the other parent as that bad, you're not trying to send the kids over. Who are you fooling? Okay? So that's what you ask for the first go round. The second go round, if that doesn't solve the problem, well, again, the most important thing is a judge saying to the favored parent or the non-compliant parent, I'm not buying what you're selling. You're non-compliant. Okay? And then if they're that bold, and many of them are to still go on, the second time around, you're saying, I want another finding, and I want financial penalties. And certainly in Ontario, in many places now, you don't have to bring a contempt proceeding, prove your case beyond a reasonable doubt to get financial penalties. It's now built in. Courts have learned about the power of $1,000 per missed visit is an amazing motivator. All the other soft stuff and promote and that doesn't come close to the motivating power of $1,000 for each breach. You get that on the second round. And I've had some cases where they are so bold. Yeah, they don't care. It's 1,000, 2,000, 3,000, 17,000, 18,000. So you're going back to court again. What do you do the third time? Well, the third time you are looking for an interim no contact order, and to give it some teeth, a restraining order. So at least in Ontario, a civil restraining order, you breach a civil restraining order, is actually a criminal act. So we're going to make sure you behave and observe the no contact by virtue of the restraining order. And ultimately, so 3 rounds of escalating sanctions. Ultimately, all that's left is to jail the person. And I've only gotten to that point once. I've jailed a father, and that was the only time that I've had to do that or got to that point, that the level of disrespect to the court system was bold with a capital B. He deserved it. Okay? It was, I think, if memory serves, he was found non-compliant or in contempt with respect to the older child. And as soon as he cut off contact with the younger child. You're going to find me in contempt? Let me show you what I'm going to do. And boom, the younger child was cut off. That's pretty bold. And that led to an incarceration order. Okay? So that's what you do. How long you wait between stage 1 to stage 2 to stage 3, you can't really prescribe it. It really depends on the level of cutoff, etc. But that would generally be advisable to do it in an escalating fashion.
So, Brian, what I'd like to just comment on, thank you for sharing that, on what you said. So if you have a child who's like 10, 12 years old, yeah, you're going to play that out and play it all the way. If you have a child who's 17, you're going to run out of time.
Right. you're going to
That's all I
go,
want to say. So you have
yeah,
to look at like what do I have to work with here? Because age of child and length of time in the courts does make a difference. Brian, it's amazing, and I invite you. I would love to get into some kind of a round table or something in conversations about the PA community because I can see how far we have come since I first ever met you and the first time you ever presented in PA, and I really appreciate your um, moving us forward from getting out of the conversation of just being about proving the words and the theory and getting into the impact and the result and the impact and the what not the result, the treatment, impact to treatment, and it saves it's like the quickest way to get where we need to get. And so thank you
yeah,
for bringing that and doing that work and the work that you continue to do. So with that,
well,
I'm going to read something very quickly for our parents and for you. Work is endless. Exercise is endless. Parenting is endless. Same with marriage, writing, investing, creating, and more. You get to choose the parts of your life, but many of the important things of life cannot be finished. Do not approach an endless game with a finite mindset. The objective is not to be done, but to settle into a daily lifestyle you can sustain and that allows you to make daily progress on the areas that matter to you. Embrace the fact that life is continual and look for ways to enjoy the daily practice.